Hello everyone, good evening, welcome to Bajirao IAS Academy. So we have been discussing important topics for Polity, mains. Till yesterday we have discussed some important topics about the fundamental rights, the preamble of the Indian Constitution and the other major and important provisions of the Constitution. And in today's lecture also we have some more important topics such as the directive principles of state policy, fundamental duties, and also the schedule 5 and schedule 6 areas of the Indian Constitution. So they are also a very important topics. So we'll try to discuss and will try to understand them in a very detailed manner so that this discussion will be specifically helpful for you in your mains examination. Now today we are going to start this discussion with the directive principles of state policy, and we all knew that the directive principles of a state policy have been enshrined in the Indian Constitution with the objective of achieving the objectives of the welfare state. So in order to achieve the dream or the goal of the welfare state, the state must implement the directive principles of state policy. However, one thing that we need to understand, that directive principles are non-justiciable in nature. So that essentially means that even if state doesn't implement the directive principles of state policy, so you cannot go to courts for the implementation of these DPSPs, right? So in fact, apart from ensuring welfare state in India, DPSPs also established for achieving the goal of social and economic democracy. They play a very important role in achieving the goal of social and economic democracy in India. So political democracy is achieved through the fundamental rights, and social and economic democracy in India is achieved through the directive principles of state policy. Now, in which part of the Indian Constitution? So directive principles of state policy are in, so part 4 of the Indian Constitution, directive principles of state policy are in, and in fact from Article 36 to Article 51 of the Indian Constitution, so it deals with the directive principles of state policy. So you should have to remember, because whenever you write a question on directive principles of state policy, it is always better that you write introduction with the articles or the part where the directive principles of state policy are mentioned in, or the objective of the directive principles of state policy, and what is the aim of the directive principles of state policy. And if you look at some details with respect to DPSPs, in fact, these DPSPs have been taken from the Irish Constitution, and this is important. You could remember this for your prelims examination, as it has been taken from the Irish Constitution. So remember that when Constitution has been framed by the Constituent Assembly, the drafting committee of the Constitution had actually taken up good features from number of countries, right? So it has referred a number of constitutions, and it has also taken good features from different constitutions, and in a similar way directive principles of state policy has been taken from the Irish Constitution. And in fact, these DPSPs are an instrument of instruction which are enumerated in the Government of India Act. In Government of India Act, remember that most of the Indian Constitution has been sourced from the Government of India Act. So in Government of India Act, directive principles of state policy are referred to as instrument of instructions, right? So you should have to remember this. And in fact, as I have already told you, that the directive principles of state policy would create a welfare state in India, and they also establish economic and social democracy in this country, and that is the objective of DPSPs. However, Dr. B.R. Ambedkar also called directive principles of state policy as novel features of this constitution. So he called novel features of Indian Constitution. Now, why he called the directive principles of state policy as novel features? Because there are number of reasons. For example, there are a number of enabling provisions which aimed at social development, economic development, social justice for the deprived, marginalized communities, and in fact the welfare of different sections of the society. So it has talked about these sections in a holistic manner, and because of that particular reason, Dr. B.R. Ambedkar called directive principles of state policy as novel features. Now we will understand some constitutional provisions with respect to directive principles of state policy. Now in fact, the directive principles of state policy are divided into three different types. Okay, so what are those three different types based on the ideological lines? For example, some features of the directive principles of state policy are called as socialistic principles, and some principles are called as the Gandhian principles. What are those Gandhian principles? So I would say that Article 40 of the Indian Constitution talks about what? So it talks about the panchayats, so local self-governance institutions, and similarly Article 43B of the Indian Constitution. So Article 43B of the Indian Constitution talks about what? It talks about the cooperative societies. And in a similar way, there are certain liberal and intellectual principles as well. For example, Article 44 of the Indian Constitution, it deals with what? It deals with the Uniform Civil Code, and Uniform Civil Code is one of the liberal intellectual principles as part of the directive principles of state policy. And similarly, we also have the socialistic principles as well. For example, Article 39A of the directive principles of state policy talks about equal justice and free legal aid to the poor. So these are the different types of principles within DPSPs, right? So first, Article 36, what it talks about. Article 36. So Article 36 of the Indian Constitution, which is part of the DPSPs, talks about, or it defines state. So it actually defines state as one which keeps in mind all these DPSPs before formulating any policy law for the country. So this is what Article 36 specifically talks about. And even Article 37, the nature of DPSPs has been defined in Article 37 in the Indian Constitution. So that essentially means, in the beginning of this lecture, I told you that directive principles of state policy are non-justiciable in nature. So that means even if state don't implement these directive principles of state policy, you cannot go to the court for the implementation of DPSPs. So Article 37 says the nature, right? So the DPSPs are non-justiciable in nature, and Article 36, it talks about the, it defines the state, and in fact, while formulating laws, the state should actually keep in mind these directive principles of state policy. Now here I have given a list of directive principles of state policy right from Article 38, as we have already discussed Article 36 and Article 37 of the directive principles of state policy. So you could also see here different articles which forms part of the directive principles of state policy as part of part 4 of the Indian Constitution, right? So in fact, whenever you write any mains answer on directive principles of state policy, it is always better that you mention these directive principles of state policy. Along with that, you should also mention some examples that what are the steps, legislative, administrative steps taken by the government for achieving these directive principles of state policy. Now Article 39, so it talks about what? It talks about free, equal justice and free legal aid. So similarly, in order to achieve this goal, so the parliament has passed NALSA Act, National Legal Services Authorities Act. So it is called as NALSA Act, has been passed in the year 1987. And in fact, Lok Adalats have been established for achieving the goal of the free equal justice and free legal aid, and Gram Nyayalayas have also been established. So you could also mention that as an example, right? So in fact, village panchayats, the government has framed 73rd and 74th Constitutional Amendment Act, right? So 73rd Constitutional Amendment Act has established the village panchayats, and 74th Constitutional Amendment Act has established the municipalities. And similarly, the Panchayat Extension to Scheduled Areas Act of 1996 has also been passed to achieve the dream of organization of village panchayats. So you should have to mention all these different provisions, so all these different legislative measures, so that it further enriches your answer as well. And in fact, Uniform Civil Code, recently we have seen Uttarakhand state legislature, Uttarakhand state become the first state to implement the Uniform Civil Code. And in fact, Goa already has this Uniform Civil Code, and Supreme Court in several cases, right, such as Shaira Bano case and Shah Bano case, the Supreme Court has actually asked the union government to consider the matter of the Uniform Civil Code. And similarly, with respect to promotion of education and economic interests of scheduled caste, scheduled tribes and other weaker sections, there are different provisions. For example, 103rd Constitutional Amendment Act talks about 10% of the reservation for the economically weaker section, and Mandal Commission recommendations are implemented, and Mandal Commission has recommended 27% of the reservation for the other backward classes, and subcategorization of OBCs. For that particular purpose, Justice Rohini Commission has also been established by the union government, so that the reservation benefits would reach to the most deprived sections within the other backward classes. And similarly, 15% reservation has been given for scheduled castes, and 7.5% reservation has been given for the scheduled tribes. And prevention of atrocities against scheduled castes and scheduled tribe law has been passed in the year 1989 to prevent the atrocities committed against the scheduled castes and scheduled tribes, right? So there are a lot of such provisions, a lot of such legislative measures have been passed by the union government, right? So for example, Organization of Agriculture and Animal Husbandry, for that particular purpose, Khadi and Village Industries Commission has been established, and for this particular purpose itself, NABARD has been established on the recommendations of Shivaraman Committee. And protection and improvement of environment, so for this particular purpose, Wildlife Protection Act has been passed. Wildlife Protection Act of 1972 has been passed, right? So in fact, Environment Protection Act 1986 has been passed, and Biodiversity Conservation Act has been passed in the year 2002, right? So there are a lot of such measures have been taken in number of areas, and it is better that you should mention those measures taken up by the government, right? So I hope you have understood this, and you can also go through all these directive principles of state policy, and it is very, very important for prelims as well, right? So now we'll understand there's a conflict that has been taking place between the directive principles of state policy and the fundamental rights. Now, through various Supreme Court judgments, we'll try to understand the conflict between the directive principles of state policy and the fundamental rights. Now, the conflict has always been revolving around one particular issue, that which class of provision should be given primacy, whether the fundamental rights should have the primacy over the directive principles of state policy, or directive principles of state policy have the primacy over the fundamental rights, is the key issue, and that has been leading to the number of judgments from the Supreme Court through various cases, right? So in fact, the first case that deals with the conflict between directive principles of state policy and fundamental rights is Champakam Dorai Rajan case of 1951. Now, in this particular Champakam Dorai Rajan case, the Supreme Court has actually upheld Article 37 of the Indian Constitution, right? So what is this Article 37 talks about? So Article 37 talks about the nature of the directive principles of state policy. And what is the nature of directive principles of state policy? They are non-justiciable in nature. And in this Champakam Dorai Rajan case, Supreme Court has actually upheld Article 37, and in fact the Supreme Court has already held that these directive principles of state policy are not enforceable by the courts. And in fact, this means that when Supreme Court has said that the directive principles of state policy are not enforceable by the courts, that effectively means that fundamental rights were given superiority, or the fundamental rights are given primacy over the directive principles of state policy, right? So this was 1951 case, and the next defining judgment of the Supreme Court with respect to directive principles of state policy is the Golaknath case of 1967, right? So what is this Golaknath judgment of 1967, right? So in this particular judgment, the Supreme Court has laid down that fundamental rights cannot be abridged or diluted for the implementation of directive principles. Now, there's always a dispute, a conflict between the fundamental rights and the directive principles of state policy, because there are some directive principles. For example, Article 46 of the directive principles of state policy. So it talks about what? So it talks about the economic and the social welfare of the marginalized sections of the society. So in order to achieve economic and educational, social benefit of those marginalized or weaker sections of the society, the state has to implement the policies of affirmative action, right? So what is the policy of the affirmative action in India? It is reservations in education and employment. So we have already understood that 15% reservation has been provided for the scheduled castes, 7.5% reservation has been provided for the scheduled tribes, and 27% reservation has been provided for the other backward classes, and 10% reservation has been provided for the economically weaker sections. So this is how affirmative action has been implemented in India to correct the historical injustice that has been suffered by most of these communities. So however, in providing reservation benefits is considered as violation of Article 14. It is considered as violation of Article 15 and Article 16 as well, because those articles believes in equality of opportunity, no discrimination by the state, right? So that's how there is always a tussle or a conflict between the fundamental rights and directive principles of state policy. And in Golaknath case of 1967, the Supreme Court has laid down that Parliament cannot abridge or take away any of these fundamental rights for the implementation of the directive principles of state policy. It has made it very, very clear. So however, after this, after the Golaknath judgment, what happened was the Parliament has passed 24th and 25th Constitutional Amendment Acts, right? So these 24th and 25th Constitutional Amendment Acts were further challenged in Keshwanand Bharati judgment of 1973. Now in Keshwanand Bharati judgment, we have understood that Supreme Court has laid down a doctrine called basic structure doctrine. Supreme Court has laid down basic structure doctrine in Keshwanand Bharati judgment. So as per the basic structure doctrine, there are certain features of the Indian Constitution. They are considered as core or the conscience of the Indian Constitution. So therefore, Parliament cannot take away or Parliament cannot amend or alter those certain features of the Indian Constitution. For example, rule of law is part of the basic structure doctrine. Secularism is part of the basic structure doctrine, and even federalism is also part of the basic structure doctrine, right? So that is how the Supreme Court has laid down the basic structure doctrine through Keshwanand Bharati judgment. However, in this Keshwanand Bharati judgment, what Supreme Court has held? The Supreme Court has said that Parliament can amend or Parliament can abridge any of the fundamental rights. Parliament can amend any part of the Constitution, but subjected to one particular condition, that Parliament cannot destroy the basic structure of the Constitution. So Parliament can amend any part of the Constitution, but Parliament cannot destroy the basic structure of the Constitution, and this is what the Supreme Court has held. So that effectively means that Parliament can actually amend the fundamental rights. So Parliament can amend or abridge the fundamental rights for the implementation of the directive principles of state policy, but with the one condition, that the amendment should not or could not destroy the basic structure of the Constitution. Right. So in fact, with respect to the conflict between the directive principles of state policy and fundamental rights, the Minerva Mills case judgment is one of the key judgment. Right. So Minerva Mills judgment in the year 1980, and in this particular judgment, what the Supreme Court has held? The Supreme Court has held that Constitution exists on the balance between Part 4, Part 3 and Part 4 of the Indian Constitution. Right. So Constitution exists on the balance, or it emphasizes on the harmony between Part 3 and Part 4 of the Indian Constitution. So giving absolute primacy to one over the other. For example, giving primacy to fundamental rights over directive principles of state policy, or vice versa, will certainly disturb the harmony of the Indian Constitution. And this is one of the very defining judgment of the Supreme Court that has emphasized on the harmony between the fundamental rights and also the directive principles of state policy. So these are four judgments with respect to the directive principles of state policy. Now you could also see here there are number of measures that the government has actually undertaken for the implementation of the directive principles of state policy, and I have already explained this to you. For example, Article 40 of the Indian Constitution, 73rd Constitutional Amendment Act has been brought in, and this 73rd Constitutional Amendment Act has established a three-tier governance structure at the local level or at the panchayat level. And Article 42 of the Indian Constitution, a code on security 2020 has been provided, and it actually provides maternity leave as well. And similarly, Article 45, right of children to Free and Compulsory Education Act of 2009 to provide for compulsory education for the children in the age group of 16 to 14 years. And Article 43, Mahatma Gandhi National Rural Employment Guarantee Act for promoting inclusive development through the guaranteed wages and uniform civil code. And Article 47, so it talks about the ban on consumption of intoxicating substances, for example, consumption of liquor and others. Right. So here also a detailed description on the differences between the fundamental rights and directive principles of state policy has been provided. So it is also very important that in your examination there are chances that you will be asked to mention the differences between the fundamental rights and the directive principles of state policy. So therefore, you should also know the differences between DPSPs and the fundamental rights. And in fact, the fundamental rights, they entail the negative obligations. They restrain the state from the interference of the individual rights when it comes to the fundamental rights. However, with respect to the directive principles of state policy, so they actually involve the positive obligations, and they also mandate the state to take a specific action. Right. So they mandate the state to take a specific action so that it would result in the welfare state, it would result in social and the economic democracy in India. So secondly, fundamental rights, we have already discussed that they are justiciable in nature. and they can be legally enforced. And if you feel that any of your fundamental rights are violated, you could directly approach either Supreme Court or the High Court. But on the other hand, the directive principles of state policy are non-justiciable in nature, and in fact the fundamental rights aimed to establish political democracy, and directive principles of state policy, they aimed to establish social and economic democracy within the country. And fundamental rights are backed by legal sanctions, and they are supported by the moral and political sanctions. And fundamental rights aimed at individual welfare, and directive principles of state policy aimed at the societal welfare. And fundamental rights are automatically enforced without requiring the additional legislation, and directive principles actually require the legislations for the implementation of various provisions. And in fact, courts can actually invalidate laws for violating the fundamental rights, and this is what Article 13 talks about, right? So Article 13 talks about this particular provision. However, courts cannot invalidate laws which actually violate the directive principles of state policy, right? So in fact, courts also take whenever courts have been interpreting any laws, any constitutional amendment acts, deciding the constitutionality of such laws or such constitutional amendments, courts actually look for the directive principles. They take the help of the directive principles of state policy as well. And similarly, the very important topic is the Uniform Civil Code. And in fact, Uniform Civil Code is always a debatable issue in India, particularly in recent times, in the context that recently Uttarakhand state government has become the first state to implement the Uniform Civil Code. And in fact, when we are discussing about the directive principles of state policy, so we have discussed that Article 44 of the Indian Constitution, which is part of DPSPs, talks about the Uniform Civil Code, right? So the responsibility or the obligation of the state to gradually implement the Uniform Civil Code. Now, in this context, there may be a question that could be asked on the Uniform Civil Code. So let's have a look at the Uniform Civil Code as well. So this UCC has been enshrined in Article 44 of the Indian Constitution, particularly in the directive principles of state policy in Part 4. And similarly, the Uniform Civil Code, it aims to replace the personal laws. Now, as of now, when it comes to the personal laws in India, so those personal laws are guided by the religious customs or religious traditions. So we don't have a uniform law when it comes to the personal matters. Now, in India, personal laws are actually based on the scriptures and customs of each major religious community, right? So we don't have a common set of law. So therefore, UCC has been aiming to replace these personal laws based on scriptures and customs with a common set of laws governing almost like every citizen, right? So that is what the objective or the aim of the Uniform Civil Code. And in fact, it will not only uphold the principle of equality. So Uniform Civil Code will uphold the principle of equality. So that is one aim and objective of implementing UCC. So equality is the objective, or equality has been mentioned in the Fundamental Rights Article 14 of the Indian Constitution. So along with ensuring equality, in fact, so as of now we have different personal laws, so it becomes more and more complex. It creates a lot of confusion. So therefore, a uniform civil code or a single common law would actually simplify the myriad personal laws currently in force in this country. And another very significant benefit of implementing Uniform Civil Code is that it could bring in gender justice. And in fact, gender discrimination, gender inequality is a very common in these personal laws, right? So gender inequality is also very, very common in these type of personal laws. So therefore, the objective of Uniform Civil Code is to protect the rights of women, so and also achieve gender justice, right? So how a uniform civil code would result in achieving gender justice? So it could offer equal rights for women who have been traditionally disadvantaged by the biased personal laws. So they are biased in favor of men, most of these personal laws. And apart from that, uniform civil code is being viewed as a tool for the integration of the entire nation, and also eliminating the divisive loyalties to laws based on the religious practices. However, implementing uniform civil code in a diverse country like India is not easy. There are number of challenges for the implementation of the uniform civil code, right? So what are those challenges? For example, we have a huge diversity, and the diversity of the personal laws, and the fear of homogenization among different communities, and even the possible opposition from the religious communities can be considered as some of the challenges for the implementation of the uniform civil code. Now we'll understand some important legislations, important Supreme Court judgments that specifically deals with the uniform civil code, right? So key developments pre-independence. One was Lex Loci report of 1840. So what did this Lex Loci report of 1840 talks about? It has actually emphasized on the need for uniform codification of laws, and it has also suggested exclusion of personal laws from the codification at that point of time, and this is what the Lex Loci report of 1840 talks about. However, after independence, so DPSPs as instrument of instructions have been enshrined in the Indian Constitution as part of Part 4 of the Indian Constitution. So DPSP's Article 44 talks about the desirability of implementation of the Uniform Civil Code. And similarly, Hindu Succession Act 1956 has been passed. So as per the Hindu Succession Act of 1956, so it has codified the law of succession among certain religious communities such as Hindus, Buddhists, Jains and Sikhs. And similarly, a Special Marriage Act of 1954 has been passed, and the Special Marriage Act has provided a legal framework for civil marriages outside religious personal law. So that essentially means that when it comes to succession, when it comes to marriage, a certain religious communities still not considered part of, or not consider the ambit of the codification or the legal framework. So that has created a number of challenges, and Uniform Civil Code could actually address those challenges, and that is the argument that experts who have been supporting implementation of Uniform Civil Code have been giving. However, in this context, we also have some Supreme Court judgments with respect to the Uniform Civil Code. So in fact, in the year 1985, in one of the judgment of the Supreme Court, so the case was Shah Bano case of 1985, and in this Shah Bano case of 1985, the Supreme Court has called for Parliament to outline for the Uniform Civil Code. And time and again, not just Supreme Court, various high courts have been stressing on the need for bringing in a uniform civil code so that the complexities of laws that have been existing in India could be avoided. And similarly, in Shaira Bano versus Union of India case in the year 2017 also, so they have challenged the practice of triple talaq, and triple talaq has been declared unconstitutional by the Supreme Court. So this has also been emphasizing on the need for bringing in the Uniform Civil Code. So however, we'll understand what is the need for Uniform Civil Code. So why it is important to bring in Uniform Civil Code. So in fact, a Uniform Civil Code will ensure equality, right? So equality in the sense that there are religious biases, there are some personal biases in those personal laws, and it is very important to treat everyone equally, both men and women, when it comes to the personal matters also. So otherwise, women would be exploited. So gender inequality would be perpetuated. So therefore, Uniform Civil Code would eradicate the religious biases in the personal laws, and it would also ensure equal rights and privileges for all citizens. And similarly, so simplification of laws. Uniform Civil Code would result in the simplification of laws, because a uniform civil code would unify and further simplify a very diverse and complex laws that creates a lot of confusion when it comes to the implementation of the direct to principles of state policy. And similarly, promoting gender justice by superseding the existing personal laws, UCC would actually eliminate the gender biases that have been existing in the implementation of the Uniform Civil Code. And freedom of choice, right? So freedom of choice in the sense that a religion neutral person, a personal law. So, a personal law which should be a religion neutral would protect the intercaste and interreligious marriages as well. Now, in India, socially, intercaste and interreligious marriages have no sanction. And protection of the vulnerable sections is also very, very important. A uniform civil code would safeguard the rights of women and the religious minorities as well, and that is very, very important here. And adherence to the principle of secularism, because UCC is essential for a secular republic to provide common law for all of its citizens. And uniform civil code would also result in the national integration as well, because UCC would actually separate religion from the social relations. Thereby, it could foster unity and harmony in the society. And apart from that, it also an indication of a progressive nation. Now, progressive nation in the sense that, for example, gender discrimination is a common practice. Gender inequality has been perpetuated in the society. And the personal laws for different religions are favoring men over women. So therefore, whenever we have a uniform civil code, so that indicates women's exploitation is arrested or prevented. So women have been given equal rights along with men. So therefore, whenever any country is having a uniform civil code, so it could be an indication of a progressive nature of the country. Now remember one thing, that we wanted to become a developed country by the year 2047. So in order to achieve that goal, not just economic development suffice. Along with the economic development, social development is also very, very important. And in order to make sure that whatever potential that women have, we need to tap and unleash the potential of a woman, and a uniform civil code a step in the right direction. And this is what the experts who have been suggesting uniform civil code have been arguing that. However, there are certain challenges and issues also which are existing when it comes to the implementation of the Uniform Civil Code. So we will also look into the challenges and issues in the implementation of UCC. And in fact, so a lot of people have been looking at the Uniform Civil Code with this skepticism that it is the interference of the state in the personal matters, and it is against Article 25 of the Indian Constitution. So Article 25 talks about the freedom of religion, so right to freedom of religion. So therefore, implementation of Uniform Civil Code is being viewed with the skepticism. It is being perceived as a reduction in the scope of freedom of religion, and that has been enshrined in the fundamental rights under Article 25 of the Indian Constitution. And in fact, so Uniform Civil Code's implementation is also being considered as a threat to the plurality and diversity of this country. Now, in fact, Uniform Civil Code aims at achieving uniformity, but India is known as a melting pot because it has different religions, different cultures, languages, ethnicities, religions. So therefore, achieving uniformity in such a huge and diverse country like India would go against the principles of secularism, would go against the principles of the religious plurality. and diversity, right? So this is also another fear when it comes to the implementation of the uniform civil code, and that may make the communities, the community leaders and the stakeholders may not come forward, they may not support the implementation of the uniform civil code. And in fact, so we have already discussed about the secularism, and India follows the positive form of secularism. Secularism is a term even though it is a Western origin, and we have our own secularism, so that is the positive form of secularism. But people view implementation of uniform civil code as a contradiction to the Indian model of secularism, because Indian model of secularism is treatment of all religions equally, so equal respect or equal treatment of all religions equally. So therefore implementation of UCC would lead to the imposition of the majority view on the minority religious communities. So therefore it goes against the spirit of Indian secularism. So that is another major concern. And in fact, there are a lot of issues with respect to the drafting of the uniform civil code itself, right? Because you cannot draft a uniform civil code that could be universally acceptable. But Constituent Assembly has framed a constitution that has been acceptable, and that is working very, very well as of now, right? Because Indian Constitution is one of the lengthiest written constitutions in the world, and it is one of the most successful constitutions in the world as well, right? So similar to the Indian Constitution, it will be very difficult to draft a uniform civil code that could be universally acceptable, that could be acceptable to almost every community. And even there are issues of drafting UCC, and minorities also have the concerns that the majoritarian culture, the majoritarian views are being imposed on the minorities through the uniform civil code, and that could even leads to the radicalization of people from the other religious communities, and that could further threaten the internal security or national security of our country as well. And even there are certain religious communities or certain religious communities which are living in certain parts of India. They could even start the secessionist movements against the imposition of uniform civil code as well. And in fact, Law Commission in the year 2018 did not suggested the implementation of the uniform civil code. Rather, the Law Commission has asked for the codification of the personal laws, but not the implementation of the uniform civil code. And this is also another argument that is being given by the experts for not implementing the uniform civil code in India. And uniform civil code as an issue is a politically very, very sensitive issue, because this is an issue which has been politicized, and the BJP government has made uniform civil codes implementation part of its manifesto. And because of that particular reason, so it is being excessively politicized, and this has been causing a friction between different communities, and in fact a constitutional hurdle as well, because it could be considered as a potential conflict between the principle of equality that has been enshrined in Article 14 of the Indian Constitution, and the freedom to practice and propagate any religion under Article 25. So it is being viewed as a conflict between Article 14 of the Indian Constitution and Article 25 of the Constitution. Now, in this context, so what should be the way forward when it comes to the implementation of the uniform civil code, right? So uniform civil code can be implemented, but not in a one single go. Rather, it could be implemented in a gradual manner, or we can say that a piecemeal approach could be followed. And in this piecemeal approach, so what the state has to do, the state has to implement the uniform civil code in a gradual manner. A gradual introduction of the uniform civil code in stages would be a more feasible option as of now. And apart from that, there should be eradication of discrimination. when it comes to implementation of Uniform Civil Code, and the government should prioritize equity and equality in the process of the codification of the laws. And the majoritarian, it should not appear that the majoritarian views and the aspirations should not be imposed or should be imposed on the minority communities. And similarly, the Uniform Civil Code implementation or Uniform Civil Code should have a inclusive outlook, because that is very important to encourage progressive thinking and also understanding of Uniform Civil Code among various religious and ethnic communities, and that makes the Uniform Civil Code implementation more and more feasible, and that could also further minimizes challenges when it comes to the implementation of the UCC. And even it is very important that there should be a large scale public debate, deliberations and discussions that took place with respect to Uniform Civil Code, because what happens is that you would inform the people with some relevant information with respect to Uniform Civil Code. You should get the opportunity to understand the concerns of different stakeholders when you are implementing the Uniform Civil Code. So such deliberations, debates and discussions should always be encouraged, and Uniform Civil Code draft should also be in public domain, and it should also get a feedback, and there should also be mechanisms to take into consideration the feedback that has been provided by the public as well. And in fact, consultations with the experts is also very, very important, right? So that ensures the drafting process respects all communities, and it is not favoring one single community. So it should not give the image that it is favoring one single community and neglecting the other community, or discriminating the other community. So it should not be like that, but the spirit is holistic, inclusive, gender sensitive, and it also focuses on gender justice and gender equality. And apart from that, the codification of the personal laws, so that is also very, very important to ensure the universal principles to achieve the goal of equity as well. And there should be a program or the campaign that aimed at outreach to the different communities, because when you are reaching out to the communities at the ground level, so there will be an opportunity to create a consensus, or there is an opportunity to inform the public with adequate information on the Uniform Civil Code, right? So you could bring awareness among the people, so that makes implementation of Uniform Civil Code would be more and more acceptable among the people. And ultimately, when you write the conclusion, you could write this conclusion that implementation of UCC, it represents a crucial milestone, a very important milestone in the country towards a more sensitive, inclusive, equal and a secular society. However, it is not free from the challenges. So it has a various challenges, but implementation actually demands more and more sensitivity, widespread consultations, and a commitment to respecting country's diverse cultural fabric. So this is how you could actually write a conclusion in the answer. And the next topic is right to health. So right to health is also a very, very important topic. So let's discuss about the right to health as well. And in fact, the directive principles of state policy and some articles within the directive principles of state policy, such as Article 38, Article 39, Article 42, 43 and 47. So these articles have been talking about the right to adequate healthcare, or the obligation on the part of the state to provide more affordable, accessible healthcare, or that we can also call it as a universal access to healthcare, right? And in fact, right to health is not formally mentioned in any of those fundamental rights, but state has an obligation to provide adequate, accessible, affordable healthcare for every citizen, right? So in fact, what is the meaning or the definition of right to health? So it is very important for us to understand the definition of right to health. Now, right to health actually refers to the means refer to and means the most attainable levels of health that every human being is entitled to. So that is the exact and actual definition of right to health. And in fact, a first state in India, so that has actually framed a right to healthcare law is the state of Rajasthan. So state of Rajasthan has framed the right to healthcare law. So no other state has this such a law. At the union level also, we don't have any such law which guarantees right to health, but we have a law which guarantees right to education. And this is the definition of right to health. And in fact, right to health is considered as essential component of human dignity, right? So it is an essential and a very important component of human dignity. And in fact, it reminds the responsibility and the obligation of the government that the responsibility to ensure that adequate health care is provided to all individuals irrespective of gender, race, ethnicity, religion, and their socio-economic status. And this is what the right to health actually talks about. And in fact, there are some international conventions also. Those conventions specifically talking about right to health. For example, Article 25 of the Universal Declaration of Human Rights. So that is part of the United Nations, right? So United Nations Universal Declaration on Human Rights, Article 25 talks about right to health. And in fact, there are some judicial pronouncements also. So those judicial pronouncements also stressed on the right to health. And in Paschim Banga Khet Majdoor Samiti case in the year 1996, the Supreme Court has actually held that in a welfare state like India, the primary duty of the government is to secure the welfare of the people and also provide adequate medical facilities for its people. So that inherently in this judgment, the Supreme Court has been emphasizing on the responsibility of the state to ensure adequate health care and achieve right to health or protect the right to health. So however, what is the significance of the provision of right to health? So we'll try to understand the significance of the provision of right to health. So it actually a rights-based health services would be given to the individuals who are actually entitled. Okay, the people who are entitled to right to health, and it creates a compulsion and obligation on the government to provide affordable care or affordable health care, and also the obligation of the state to take steps positively to achieve or to protect the goal of right to health care. And in fact, it also ensures wider access to healthcare services. Now, wider access to healthcare services is very important to protect the right to healthcare and also ensure universal access to healthcare. Universal access to healthcare. So therefore, it could actually ensure that the quality of those services is good enough to improve the health of the people who actually receives the healthcare facility. And apart from that, right to health or the obligation of the state to protect right to health would also substantially reduces the out-of-pocket expenditure as well, because as per some data provided by the National Family Health Survey, the out-of-pocket healthcare expenditure in India is 43%. That is substantially very high. However, right to health puts an obligation on the state, and that would help reducing the out-of-pocket healthcare expenditure, right? So it protects people from the financial consequences and also reduces the risk of people getting pushed into the poverty trap or chronic poverty cycle. However, when it comes to the right to health structure, that means we have just 1.4 beds per 1,000 people and one doctor for 1,445 people and 1.7 nurse for 1,000 people, right? In fact, 75% of the healthcare infrastructure is just concentrated in the cities or urban areas, and 27% of the total population resides in the rest 73%. India's population resides in rural areas where even basic medical facilities are lacking. And in fact, we also have a high disease burden. So India has a very high disease burden of communicable and non-communicable diseases such as tuberculosis, HIV, AIDS, and diabetes. So that would also increases the healthcare costs as well. And we also have a huge gender disparities, because gender disparities, particularly women are facing a lot of disparities because they having limited access to the healthcare, and higher rates of maternal mortality, and also the gender-based violence as well. And even limited financing in the healthcare, that we have been spending just 2.1% of our GDP on healthcare in the financial year 23. That is substantially lower than the global average of 5.2%. And what should be the way forward in this context? So India needs to substantially increase its investment in the healthcare infrastructure, and India should increase its GDP, so increase its spending on healthcare to 3% of its overall GDP. And India should focus on substantially strengthening medical facilities, equipment, and also the healthcare professionals as well. And India should also improve access to healthcare. For that, India needs to address barriers that actually prevent individuals from accessing the healthcare services, including financial constraints, transportation, and discrimination. And this goal can be achieved through targeted policies, right interventions, programs of the government, and providing insurance access to everyone, particularly poor, and setting up the mobile healthcare units in rural areas, which are unserved, underserved, or unconnected areas. And it is also very important that there is a need to create a designated autonomous agency to perform the functions of disease surveillance and information gathering. So all these things would help achieve the goal of right to health, or protection of everyone's right to health, right? So that's all in this lecture, and some more topics we will discuss in tomorrow.